சென்னை உயர்நீதிமன்ற கூட்ட அரங்கில் புதிய நலத்திட்டங்களை தொடங்கி வைத்த பின் உச்சநீதிமன்ற தலைமை நீதிபதி NV ரமணா பேசி வருவதை தற்போது நேரலையில் காணலாம்.
Across the country, there are 388 vacancies. From day one, it has been my endeavor to fill judicial vacancies. In fact, my very first communication to the Chief Justices of the High Court was to request them to expedite the process of recommending names for elevation. Due to collective efforts at all levels, we could make considerable progress in the filling of the judicial vacancies. After I assumed office, we made 180 recommendations so far for appointment in the High Courts. Out of these, 126 appointments were made. 54 proposals are awaiting for approval before the government. The government has received nearly 100 proposals from various High Courts, which is yet to be transmitted to the Supreme Court. I am hoping that the High Courts will expedite the process of sending the proposals to fill the remaining 212 vacancies. Another issue I want to discuss is that of the language used in the courts. The common citizen of this country cannot relate to the practices, procedures, and language of our courts. Our efforts should be connected in making the general population an active part of the justice delivery process. The parties must understand the ongoing process and development of the case. It should not be like chanting mantras in a wedding, which most of us do not understand. From time to time, there have been demands from various regions to allow the use of local language in the proceedings before the High Courts as provided for under Article 348 of the Constitution. A lot of debate has taken place on this subject. There are certain barriers that have prevented local languages being adopted in the proceedings before the High Courts. I am sure within innovation of the science and technology, the advancements such as artificial intelligence, some of the issues associated with the introduction of languages in High Courts may be solved in the near future. The practice of law before constitutional courts should be based on one's intelligence and understanding of law and not mere proficiency in language. It is time for some decisions to be taken on this issue after assessment of the pros and cons. Inclusivity is one of the most important dimensions of unionization. Any profession having representation from all classes and sections will be beneficial to all. I have been a strong proponent of higher representation of women at all levels of the legal profession. Speaking of women particularly, we need women from all classes and all sections to find a place within the judicial system. As Mahakavi Bharati said more than a century back, and I quote, "Anum pennum nigarana kolladal arivilongi evvayam talaikkumam." That means the world will prosper in knowledge and intellect if both men and women are deemed equal. Inclusivity does not stop only representation of women. The social and geographical diversity of the nation must find a reflection in all levels of the judiciary. With the widest possible representation, people get to feel that it is their own judiciary. Everyone has a voice in the system, that is, and they form a substantial part of it. In fact, we are awaiting a day where persons' gender, orientation, birth, or identity would not act as a barrier. For example, a judge from a rural background is better placed to appreciate issues concerning the rural population. A judge from a particular region understands the issues of that area better. A judge from marginalized section understands the issues of marginalized better. Another aspect of inclusivity relates to the geographical barriers faced by both litigants and lawyers. While appearing before the constitutional courts, a member of this bar, senior advocate and parliament member, Sri Wilson, was introduced a private member's bill to enable setting up of regional benches of the Supreme Court. I am not aware if the government of India has expressed its view on this subject, but in the same spirit of accessibility, I have, in consultation with my brother and sister judges in the Supreme Court, continued the online hearing of miscellaneous days which we had started during the pandemic. On non-miscellaneous days, advocates can still seek the permission of the court to appear online. This is enabled advocates from all over country to continue their practice before Supreme Court. I hope this practice will continue and strengthen in the future also. Now, majority of the advocates across the country, they are appearing online and arguing their own cases. The Bar Council of India and state bar associations have taken several steps to eliminate conditions of the lawyers during the pandemic. Now the Chief Minister has announced